Okay, welcome to Unit 4.2, Planning. So this is the planning unit, and we've just looked at how planning decisions are made at County Council and Board Penola level. Now we're going to look at court supervision of those decisions, or court oversight, through the process known as judicial review. And this is divided into two parts because judicial review is quite complex. So right now we're going to look at part one, which are an overview of the principles governing judicial review. So what is judicial review? So judicial review translates as judge review. That's what it means. It's a review of the decision of the administrative tribunal, like on Board Penola or the County Council, and by a judge of the High Court. And it's always by the High Court. So the High Court is given by the Constitution this supervisory power over decision-making bodies like the County Councils, on Board Penola, and also in other areas of law outside of planning, the Workplace Relations Commission for Employment Law, or the Refugee Appeals Tribunal for Asylum Law, and all other public bodies as well. So grants authorities, so SUSI, who make the college grants to students, are covered by supervision by the High Court of their decisions. If they make a bad decision, it can be challenged in the High Court. The Department of Agriculture making grants to farmers, county councils making grants to community groups. Any decision by a public body, so a government-funded body, that affects your legal rights is subject to supervision by the courts. And this is to act as a check and balance on those decision makers to make sure they do their job properly. It also allows citizens to oversee the actions of public bodies, so it's a very important element of democracy and accountability. So what can be reviewed in judicial review? So all decisions affecting legal rights and interests made by public bodies. So they're the two criteria for when you're entitled to judicial review. So you must be talking about a legal right which is harmed by the decision, and the decision must be made by a public body. And so some of the examples we've looked at already are decisions by county councils on planning applications, decisions by on Board Penola on planning appeals, grant applications under derelict sites legislation or under historic sites legislation. There's a diagram of when a decision is judicial review available at that link there from Ashurst, which is an English bar association. So they're a group of barristers, and they have a really good table of when a decision is a judicially reviewable decision, and that's up on the Moodle page. And there's also a video by Terry Gorry explaining the basic principles, so it covers the similar material that we're covering here, just from a different point of view. Terry Gorry's an employment law solicitor, so it gives a slightly different spin on it. So Ray Loftus and Brian's estate in 1942, they said in this case that the government couldn't exempt any public body from the process of judicial review, from that oversight by the High Court. So here the government tried to write legislation that would take the Land Commission outside of the supervision of the High Court. So the Land Commission were a body that after independence were charged with giving land taken back from the Brits to out to Irish people so that they could become landed again after many people were rendered landless in the struggle for independence. And the Land Commission, they tried to exempt it from the supervisory jurisdiction of the High Court, and this was found to be contrary to the Constitution, because the Constitution makes the High Court the supervisory court over all public bodies. So you can't get out of it with legislation, because the Constitution trumps legislation in terms of sources of law. So the grounds of review. So on what grounds can you ask for a decision to be reviewed? So this is really important. Generally, judicial review looks at how a decision was made, not why a decision was made. So they look at the procedure followed in making the decision, and they make sure it's procedurally correct. So did it follow the rules applicable to that particular type of tribunal, which are usually set out in the legislation establishing it? And they look at did they follow common sense and fair play, or as they're otherwise known, the principles of natural and constitutional justice. And they don't look at the decision itself. Was it a good or bad planning decision? So the courts are not planners. They don't substitute their expertise for that of qualified planners in the County Council or on Board Penola. And only in very rare circumstances will they overturn a decision on planning grounds. So it's usually on procedural grounds only. And that's very important to remember about the judicial review. Usually, so 99% of judicial review is about the procedure followed in making the decision. Was it correct procedure? Was it fair procedure? And not about was it a good or bad planning decision itself. So the decision maker must follow the rules applicable to that particular scheme of decision making set out in the statute creating it. So in this case, the Planning Act, and they must also follow natural and constitutional justice principles as well. So natural and constitutional justice is, as I said before, this idea of common sense and fair play. And there are some examples here. This is not an exhaustive list, but it's just a few examples of what is meant by natural and constitutional justice. So these have like Latin names, and it's important to be aware of the Latin names because that's how they'll be discussed in textbooks and cases. But they have very simple English translations. So, for example, audialter impartium means to hear both sides, and it simply means the decision maker, when they're making a decision, must give equal airtime to both parties in the case, and must allow both parties to put their points forward equally, rather than letting one party have monopolise the time at the hearing at the expense of the other party's opportunity to make their points heard. And nemo iudex in causa sua, it means no man shall be a judge in his own cause, and that simply means the decision maker should have no connection to the parties in the case before making the decision. If the decision maker has a connection to one of them, like as a friend or relative of one of the parties in the case, they should stand back from the case. And that applies to county council planners, it applies to on board Panola decision makers, it applies to judges in the High Court, in any court. And so that's a principle applicable across the board. Constitutional justice is this idea of the fair trial rights that are in the Constitution. So Article 38 of the Constitution gives you a right to a fair trial, and it encompasses a lot of the principles there's a big overlap between constitutional justice and these principles of natural and constitutional justice. So it's the basic idea of were fair procedures followed, or was the decision-making process completely unfair. Ultra vires means outside the powers. So the planning authority only has the power to act in accordance with the Planning Acts. If it acts in a way not permitted by the Planning Acts, it's outside of its powers, it's ultra vires. Any decision made by a body that is outside its grounding statutes will be invalid for the reason of being ultra vires. Legitimate expectation is the idea that if a public authority makes a promise, they have to uphold that promise, especially if you relied on it. So if you can show you relied on a promise made to you by a public body, so you acted some way to your detriment as a result of a promise made by a public body, then you can sue them to uphold that promise through judicial review. So duty to only consider relevant matters and not take into account irrelevant matters and improper purpose is also important. So it's this idea of the decision maker shouldn't be biased. They should only consider evidence that is relevant to the case, and they shouldn't consider irrelevant evidence. So, for example, if the objector made out that the developer had criminal convictions for theft in his past, like that doesn't make him look very good, but that's irrelevant to whether the planning matter should be granted permission or not. And if the decision maker takes that submission into account, then they've taken into account an irrelevant matter in breach of the principles of natural and constitutional justice. In State Haverty and on board Panola in 1987, the court said that the essence of natural justice is it requires the application of broad principles of common sense and fair play. And that kind of really captures what they're trying to get at here with these 6 principles. It's like the decision should be made in a manner that is fair and follows the rules of common sense. It shouldn't fly in the face of reason. So it should be reasonable and it should be fair. And this is a very basic sense of fairness that anyone can understand. And usually people can identify when a decision is made unfairly. So it's important to remember that your fair procedure rights depend on what you have at stake in the situation. So you get a very limited range of fair procedure rights when you've got very little at stake. On the other hand, you get a wide range of fair procedure rights when you have a lot at stake. So they said there's a spectrum, and at one end of the spectrum it may be sufficient to afford a party a right to make only informal observations. At the other end of the spectrum, constitutional justice may dictate a party should have the right to be provided with legal aid, cross-examine witnesses supporting the case against them, and so on. So your fair procedure rights depend on how much you have at stake. And they went on to say that an objector would have less rights compared to a developer or landowner whose property rights would be affected by a planning decision. And this is similar to an employment law where you have fair procedure rights for any decision made by your employer of a disciplinary nature against you. But when the employer makes a verbal warning against you for being late, you don't have a right to a full oral hearing and to cross-examine the witnesses against you. But if your employer is proposing to dismiss you for theft, you would have the right to bring a lawyer, the right to have a hearing, the right to be notified of all the evidence against you in advance, and so on, the full gamut of fair procedure rights, because so much more is at stake, your employment's at stake. So there's a spectrum or a range, and so in not every situation will the full range of fair procedure rights apply. But common sense and fairness always applies. Okay, so the courts are looking at procedure followed in making the decision. When will they look at the substance? So this is only in a very rare, probably like 1% of judicial reviews, will the courts actually look at the decision and say, actually, it's irrational, it makes no sense. We should look behind the procedure to the actual substance of the decision. And the criteria for doing that is what's known as administrative unreasonableness. So the decision must be on its face completely unreasonable. So generally speaking, the court will only review a decision on procedural grounds. It will not revisit the substance of the decision. They will not look at the decision and say if it's a good or bad decision on a substance grounds, on planning grounds, because they respect the expertise of the decision maker, and they will not substitute the court's expertise for that of a qualified planner. But in rare and limited circumstances where it's really obvious the decision just makes no sense, then they might do that. And so unreasonableness is where the decision maker is shown to have disregarded fundamental reason and common sense in reaching a decision. So that's from Simmons' text available in the Library on Planning Law, and it's a good definition of it. So example there, Ashburn Holdings in 2002, the court held that certain conditions attached to a planning permission were invalid as unreasonable. In particular, the conditions requiring public access to the land had the capacity to frustrate or render it inoperable for use as a golf course. So the planning authority tried to attach conditions to a grant of planning permission for a golf course that said they had to keep the land open to the public. Obviously, golf courses are usually private membership that are expensive to join, and you wouldn't be able to maintain that if the land was publicly accessible at all times. So that wouldn't work. So the bottom line is the courts respect the expertise of the specialist decision-making body, which is why they're making the decision in the first place, that specialist decision-making body. But yet still they oversee the decision-making process to make sure it's free from procedural irregularity. And so the way they put it in the courts was the freedom to exercise discretion as in make a decision necessarily entails the freedom to get it wrong. This does not make the decision unlawful. So making a mistake in a decision does not make the decision unlawful, but failing to follow fair procedures does. Okay, so that's it for the first part of Judicial Review Part 1. So you can move on now to the next video, which is Judicial Review Part 2, which looks at the principles of natural and constitutional justice in detail.